Or not, but he is not able to give me a straight answer on whether he wants to proceed with trial or whether he wants to take the office in the state.
Bring him out, Judge.
He has expressed that he would like to sign and doesn't want to go to trial, but he's not able to sign today.
Mr. Aguilar. I see, he was evaluated in April.
He was also current, actively taking all of his medications.
Mr. Aguilar, hi.
What's that?
Next is called the State of Texas versus Xavier Ian Aguilar. And that's you, sir?
Yes, sir.
In 24 CR 1941. And earlier, there was a question about competency, which has been resolved. Dr. Edgar Pond, you met with Dr. Edgar Pond, remember? And he evaluated you, and you are, like everyone else, unique. Everybody on the planet is special and different. And you, though most importantly, are competent to move forward with a trial. This indictment alleges that you committed the third-degree felony of assault on a public servant, which would normally carry with it on a third-degree felony, if convicted, no less than 2 nor more than 10 years confinement in prison, and a fine up to $10,000 could be assessed. However, there are, it looks like in 2020, you were finally convicted of illegal possession of a controlled substance in 2020 out of Montgomery County, Texas. And then thereafter, after that was final, it is alleged here that you committed another felony of illegal possession of a controlled substance out of Montgomery County, Texas. So if all of this is true, the way I'm reading it, correct me if I'm wrong, if convicted of this new offense of assault on a public servant, which is, you would be looking at no less than 25 years in prison.
That's correct.
Up to life imprisonment as what we call habitual felon. So it's very serious. And Ms. Minaldi has been appointed to help you. She's a very good lawyer. Please heed her advice. You can make your decision. It's your choice. It's your life, like everybody. But she gives very good advice and works hard for her clients. Now, I thought there was going to be a resolvement in this case, but maybe I thought wrong.
Judge, we had offered something substantially lower than the 25-year minimum, I believe 7 years. And we're being told that he wants to plead, but he doesn't want to do it today, or he's got some reason why he just feels like he can't do that today. And frankly, I'm considering just pulling the offer entirely if he's just going to keep messing around.
Well, like every Mr. Aguilar, most cases are resolved by agreements between the parties, plea agreements, and
I know,
but
feel appropriate
hold on.
answering the statement that he clearly described, Your Honor.
Hold on for a second. Just listen to me first, okay? And then so we don't speak over each other. Did you hear? There's an offer that's been made to resolve this case for 7 years imprisonment, and it's your life. You get to decide and make sure you think that you don't feel pressured, but everybody has to. They can't just dwell on it. You've got to make a decision because that's one direction it heads in. Now he's just stated that he's considering revoking, withdrawing that agreement, and then just moving forward, I guess, for a trial.
Yes.
And they can do that if there's not an agreement reached. So it's your life and it's your decision. And that's the way all plea agreements work, is an offer is made, the defense considers it. Most cases are resolved of that way, but not all of them. And that's why we go to trials. And it's just when there's what we call habitual felon status, where you're looking at a minimum of 25 years in prison, that is just, please think long and hard about making the right decision and considering the advice that you give, because you don't want to make the wrong decision. And it's your life. You get, just like I do, make decisions. But he said that's the offer that's on the table. I think Ms. Minaldi has discussed that with you. Just let me know now, because this is the time, this is going on a year since this was indicted. What do you want to do? Do you want to accept that offer, or do you want to go, which is your right, deny that offer, and then we'll just set it for trial? What do you want to do today? It's your choice.
I would just say, I want to accept the offer under, not guilty, sorry. So
He wants to accept the plea offer by pleading not guilty.
You mean no contest? That's a no contest is what some people do, where they are pleading no contest to it and accepting the punishment, and then the court will make findings based upon evidence that's presented that there. I would never find anybody guilty unless the court or the fact find the jury this determines beyond a reasonable doubt. But some people don't like to plead guilty, but they will accept the responsibility, plead no contest. And if that's done, it has all the legal effect. It works like a plea of guilty, only it cannot be used against you in any other legal proceeding, like a civil suit against you. If somebody sued you, for example, out of this, that's the big difference. But some people, it's rare, but some people plead no contest, and evidence is presented to support the elements of the crime, and the court finds the defendant guilty and moves on if there's enough evidence. And generally, there's always sufficient evidence. But there are three pleas that can be made: guilty, not guilty, or no contest. Guilty and no contest will dispose of the case without a jury. Not guilty, unless you want the judge to make the decision, we will put it on a trial, set it for trial. And then the state is inferring that you're going to be looking at a minimum 25 if convicted. And it's your life. You get to decide which direction it heads in. Do you want to accept the offer and you can plead guilty, or no contest? And then that would dispose of the case for the agreement that had been reached between the parties. Or let's put it for trial. Your choice. What would you like to do? I know you've had a chance to think about it, and this lady's very nice. She works with defendants all the time, and she makes sure that you are clear in your understanding of what's going on here. You want to set it for trial? It will be done. Do you understand, if found guilty, the minimum sentence is 25 years in prison? Do you understand?
yes, sir.
All right.
Judge, I'm requesting an attorney from the will be appointed to represent the trial.
It's his choice. She can handle this trial, but it's probably, do you want this to move quicker and get this done quicker? Then I find good cause to release Ms. Minaldi, the next lawyer on the trial docket wheel. And I presume you were unable to hire a lawyer. Is that correct, sir?
Yes, sir.
Then the next lawyer on the trial docket wheel will be appointed to represent you. You make sure that there's an indigent affidavit on file here, because I'm looking real quickly. I don't see one of all the things that are filed. I don't see them. I don't. You're going to. I see something that was signed on 11/7, which reflects the defendant is your only income is Social Security. You don't even get that. It said you had Social Security of $900, but you don't even have that. You don't have any income at all, sir. The court will then find, just with what's been on file that he signed, is still completely. It satisfies indigency, and those orders will be made. We will set this on the trial docket as soon as possible. And do you understand? We've been talking about this. The state has withdrawn their offer of 7 years, if that's what you're going to do. Do you understand you're facing a minimum of 25 years in prison if found guilty? Now, you're presumed innocent.
So yes.
You understand all of that clearly,
Okay.
and this is what you want to do.
Yes, sir.
All right, it shall be done, sir. Thank you. Okay. It's Mr. Aguiar, and that's it for him. I've got David Booth. David Booth next, please.
You'll need something or what?
And thank you very much. Okay, 25 CR 292 is now called. Ashley McKinney, that you, ma'am?
Yes, sir.
With your attorney, Mr. Dusler, and the state's attorney does the defendant waive a formal reading of the indictment and the arraignment here. Can we proceed in a summary basis?
Yes.
In summary, this indictment alleges that on or about January 24th, 2025 in Jefferson County, Texas, you committed the second-degree felony of robbery. Do you understand what you're charged with in the indictment?
Yes.
Looks like an agreement has been reached where you would be pleading guilty to the lesser included Class A misdemeanor of theft, which carries with it up to 1 year in jail and or up to a $4,000 fine,
Yes.
correct?
Yes.
Okay. It's 1,000, isn't it? 4,000.
4,000 on Class A, Judge.
So do you understand the punishment range, man?
Yes, sir.
An agreement has been reached. Well, you have a real animated,
Pretty big.
Sorry.
it's an agreement has been reached. What's the agreement?
1 year county jail, probate for 2 years with a $200 fine.
She's in custody because of a failed drug test. The concept is to get her some drug treatment, Judge.
Okay, all right. So the agreement states that you would be placed, sentenced to 1 year in the county jail. That would be suspended. You would be placed on regular probation for 2 years. Fined $200. Is there any restitution here?
None, Your Honor. The items were recovered by my memory.
There would be terms and conditions of probation, which are normal and customary for a theft. Also, the probation office will do some research and determine what type of substance abuse issues you may have that we can address that will help you complete your probation successfully. Is that your understanding of the plan?
Yes.
If I follow this, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge, this lesser included Class A misdemeanor of theft, guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty of this lesser included offense? I show you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Did you understand it, discuss it with your attorney, or the contents true and correct? State's Exhibit 1 tended and
No.
without objection admitted. The state you were mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You were guilty of the crime charged in any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses, totally satisfied with the representation provided by your lawyer. All true, so help you God. State's Exhibit 1. It's made a part of the record for all purposes. Pre-sentence report is
Yes,
awaited here. I'm going to follow this agreement if nothing further. I'm going to find you pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea. State's Exhibit 1 admitted to find you guilty beyond a reasonable doubt, and I now find you guilty of this lesser included Class A misdemeanor of, and I'm following this agreement. You are hereby sentenced to confinement in this county jail for 1 year. That's suspended. You are placed on regular probation for 2 years. You will be fined $200, and there will be other terms and conditions of probation, which are not only normal and customary for this type of offense, but also we will add substance abuse treatment, which will help you successfully. Thank you. Please see the probation officer. Good luck, man. You or Mr. Sylvester?
Yes, sir.
If you can stand right there. Thank you. You were Mitchell Joseph Sylvester.
Yes.
And your attorney, Ms. Minaldi, is here, and the prosecutor is here. You are charged in 25 CR 307 with aggravated robbery, which, if convicted, carries with it no less than 5 nor more than 99 years confinement in prison or life imprisonment. And also you could be fined up to $10,000 as well. Do you understand what you were charged with here, sir, and what the punishment range is applicable?
Yes.
But under the law, the punishment range is based upon two basic principles: the circumstances of the crime and criminal history. And the indictment states you were convicted of an aggravated robbery out of the 252nd District Court of Jefferson County in 1980. After that was final, this states, the next paragraph states, you then committed the felony of illegal possession of a controlled substance and were convicted in 1988 in this court for illegal possession of a controlled substance. And the indictment goes on to allege that after that 1988 conviction was final, you committed the offense of illegal possession of a controlled substance and were convicted of that in 1991 in the court next door. And after that 1991 conviction, 3 convictions in sequence, then it is alleged that on or about February 16th, 2025, you committed the current first-degree felony of aggravated robbery. If all of this was proven true, the prior convictions and this indictment, then your punishment range is not 5 to 99 or life imprisonment. It would be no less than 25 years, a minimum of 25 years. It starts off at 25 all the way up to life in prison. Do you understand what you're looking at in this case if found guilty? Serious. Okay, life, the rest of your life. I see you were born in 61. Well, 25 to life is pretty much does it out. Well, that's a substantial part of the rest of your natural lifetime. All right. Was there an pending here? Because rarely are these habitual, we call it habitual felony cases. Often they are worked out somehow without looking at a minimum of 25 to life. But what was?
Yes, Judge. So I had negotiated with Mr. Boyd to get a 20-year offer. So the offer would be 20 years TDC, which is less than the minimum that he would see at trial, but he is still electing for a trial.
And you actually, because of the nature of the offense, you would have to perform at least 10 years before you're parolable.
That's correct.
But you could be parolable, subject to parole in 10 years of us like this. But if it's 25 or more, that's 10 years will pass and you're going to be serving more time if you're convicted and sentenced to the minimum 25 up to life. So have you had a chance to really think real hard about it and talk to your attorney about the ins and outs about what your options are?
Well, she just came and see me the other day.
Okay. Well, I mean, did she talk to you about what options are? Well, have you had enough time to think about it?
What's up?
Well, how much time do you need to think about it? You and I are both getting older every minute. Well, how much time do you need to think? I mean, you've had to think about it since, when did you go see him?
So I'm yesterday, and then before that, I saw him a couple of weeks ago, maybe a month ago.
Okay. When was the offer presented to him?
The offer was originally 30, and I presented that offer to him, and
And then you negotiated it down to?
That's correct. So he was presented with the 20-year offer to this morning. So it has been 30 and we've come down to 20 and he has not been aware of the 20-year offer until this morning.
What's the state's position on this? If it's not accepted?
It's Mr. Boyd's case, and he told me before he left to go upstairs to meet with a witness that if he rejected the 20 today, that the offer was 30.
The offer would be back to me. Do you want to go in there and think about it a little longer? Because I've got another matter, but we're going to be finished. This is the last. Do you need any more time to think about it or not?
Yes, sir. There is.
Well, you had to be thinking about it since this occurred and you were arrested, in February, right? 4 months. But how much time do you need to think about it? Because they're giving you kind of a deadline here, it looks like.
I need another month or two.
Sir,
One or two.
a month? I don't think that's gonna be in the game. That's not what they're saying.
I was told, yes, today. And I don't really have the authority to go beyond that. It's not my case.
Any input from the defense? And
I mean, I think that.
it's his life. It's his life, and everybody in here, you and as well as me, we all have decisions that are ours to make. And it sounds like you've been informed of what your options were. You understand what the options are. You don't have many options here. You can certainly, and you're presumed innocent. That's the way the law is. You hadn't been found guilty of the crime. If you were found guilty, the way it sits, you're looking at a minimum of 25 years up to life in prison. But that's, you were there, you know what's best, what the facts are, but the state has their position, and they're saying that if you don't accept the deal now, then it's revoked, and the only other option is we set it on for trial, and you don't get the deal, you're looking at a minimum of 25. So I don't know, it's your call, but you don't have months to think about it. You've had to have been thinking since February 16th about what potential options might happen. So I know but everybody in this room has the same dilemma. They have to decide what nobody can make the choice, but the defendant, him, you, me, when I make choices that are mine, and people can give you input, but it's your choice at the end of the day. What do you want to do?
Either way it go, I'm doomed. I take 25, 20 or 30, either way it go, I'm not coming back to the world.
Sir, I'm older than you are. And I hope to live a lot longer.
I hope
But you too, well, I'm pulling for you. But what I'm saying is that in 10 more years,
Probably could.
you're not that old. I mean, you're thinking that, but it's your choice.
Judge,
Something other than incarceration, the rest of you. But in 10 years, you still have, I think the average lifespan is more than that of 10 years, but maybe you're just not as hopeful as I am.
given that I just received the re-offer of 20 years today, and he has a very big decision to make, could we request for a 1-week resetting to give him time to think on
Well,
that?
I can't. The district attorney's office.
I will just, for purposes of kind of what I've seen here, hold it open, or ask Mr. Boyd to hold it open until that 1 week when he comes
They're gonna
back.
give you a week to think about it.
But
That's more than fair.
after that, it's over.
Is that good for you to think about? All right, why don't we reset that 1 week? Okay, and we'll bring you back next Monday and we'll see what happens.
Yeah, sure.
Okay. And feel free to talk to this lady so she can answer any questions that you might have to make this decision easier to make, the proper one in your situation. Okay, all right, thank you. Yes, sir. On Mr. Simon?
I've got the
Okay,
video judge.
Just to make sure, we already did Kenneth Randolph and all those.
we don't have anything else.
Okay. So we don't have any others.
No.
Okay.
Just some.
David,
Thank you.
here's David Grove's cases from the other day on Katie Knight.
That's right, that's right.
It's right. He said he's gonna be here at 1.
Okay, it was David's, now it's Rife's. Okay, they'll be here at 1, okay. All right, let's, first of all, where is the defendant in this? Do we know?
I was getting this copy, Judge. I was able to determine that I'm.
Now we can call 23 CR 1657, the state of Texas versus Tyrese Simon. That's you, sir?
Yes, sir.
Present with Ms. Manaldi, your attorney and the state's attorney. Does the defendant earlier in this case, you were charged by an indictment handed up by the grand jury on October 11th, 2023. It's over a year and a half ago. Charging you with the second-degree felony of aggravated assault with a deadly weapon. And then you entered a plea of guilty March 17th of this year. And the agreement stated that whatever sentence shall not exceed a cap of 10 years in prison. A pre-sentence report has been prepared in this case. Have the parties had an opportunity to review it?
Yes, Judge.
And are there any corrections or changes to it?
Not to my knowledge, Judge.
Yes, and there are no changes, Judge.
All right, then it will be made a part of the record for all purposes without changes. The agreement, what was the date that this was into, please?
I believe you said it.
March 17th.
It might be in
I
my,
don't think so.
hold on, it might be in my retrieve. Let me look.
It's not, yeah, March 17th is not a date that I'm showing.
It's in my retrieve.
I don't know what that means. Retrieve, that's
Yeah,
to get something back.
It's also a pretty good
Going,
dog,
you know,
actually.
like a retriever,
Yes, sir.
a golden retriever. Chesapeake Bay,
Well, I have them in my retrieve for,
It's a good dog, Judge.
they're good dogs, smart dogs.
it'll actually be under February 24th.
So then, what we were looking at looks like two options.
Yes, Judge.
Second degree felony, aggravated assault, no less than 2 nor more than 10 years confinement in prison. It would have been up to 20, is 2 to 20 is the punishment range for a second degree felon, but your attorney was able to limit the exposure to a maximum of 10 years, but it's 2 to 10 years in prison. Also, you could be placed on deferred or unadjudicated probation, actually, which could be up to 10 years in length, where you would not be found guilty. It would be a form of probation. Regular probation is a third option under law, but you're not eligible for it. Whenever a deadly weapon is used in the commission of an offense, then a court cannot, the judge cannot grant regular probation. So a pre-sentence report has been prepared. There are no objections to it,
Correct.
and it is made a part of the record for all purposes. All right, Ms. Minaldi, on behalf of the defense, you may argue on his behalf.
Yes, Judge. Obviously, we have an option that we are advocating for today. We would request that he be put on deferred or unadjudicated probation for this offense. As you'll note in the pre-sentence report that you have in front of you, and that's been made a part of the record, he has no felony convictions or really any felony issues that he's been charged with as an adult. He has a support system on his behalf, and I do have 2 letters from his family members if you would like to read over those as well. But he has 2 people in the audience here that are supporting him today. He has the support system at home. He has an uncle who's willing to help him find a job and kind of get away from the lifestyle that he was wrapped up in down here. At least through my conversations that I have had with Tyree in the jail, and since all of this has happened, he has grown very aware of real consequences and real adult consequences, especially since being in the jail. He has expressed a desire to change and rehabilitate and be a law-abiding citizen and a productive member of society. So given that he does have no felony convictions yet, and he has not had a real opportunity at probation, I think that he has spent a lot of time in jail awaiting this point that has given him a different outlook on life. And then from there, he knows what he needs to do to be successful on probation, and he should be given an opportunity to be successful on that probation.
Abstain.
Your Honor, this is the 8th individual out of 10 or 11 that are going to be coming before you about this fact pattern. You have previously sentenced the 7 before. Each have made similar arguments like what was done here. Some were actually situated a little bit better than Mr. Simon as far as the fact pattern is concerned. Each of those individuals received pen time. 2 of them were on probation at the time, and after motions to revoke probation, either hearings or not, one was sentenced to 20 years. That was Mr. Michael Williams. Jalen Foxall was sentenced to 15 years. You've sentenced Beatty to 10, the 2 Petrie brothers to 10 years, Charles Johnson to 8 years, and Deion Brooks to 8 years. I read nothing in this report that suggests that Mr. Simon should be treated any differently. The video you've seen on multiple of those sentencings is that if you, I need to know if you recall it. If not, I'd like to play it for you.
No, I remember it, but I want
The
to look
specifics
at him.
The specifics about Mr. Simon is the PSI, which is not objected to, tells from the police version that he was striking Mr. Jefferson with a closed fist while carrying a handgun. He is not accepting responsibility fully today. He denies having a weapon. Now, I think that's probably because some of the other defendants that were sentenced were able to get less than 10 years. They got 8 years. And I think factually how that played out is they were not in possession of a weapon. They all collectively acted as a mob in assaulting Mr. Jefferson in one of the more disrespectful acts that we've seen in court as far as the video is concerned. And I know you've got other colorful ways to explain it, but the amount of lawlessness that occurs here at 3:30 in the morning in our county is really it's disappointing at best.
Normal people are asleep or at work.
So, Judge, I'll need to make arrangements to get that video ready for you. I had hopes that you would recall it, but we can do that, Judge. I just need to make arrangements to do that.
I'll see what this says. I just
Sir.
confirm it with the video. I
Yes,
know
sir.
what this says in the pre-sentence report, which says he admitted involvement in the altercation, but claims other subjects were the ones in possession of firearms, not him. Where does it show? I'm going to get this. Mr. Simon, according to probation, was wearing a white t-shirt and green shorts, was striking Jefferson with a closed fist while carrying a handgun.
If you'll give me a few moments, Judge, I know I've got some trial copies of, because we have two defendants that are set for trial. I've got some trial copies of those videos upstairs, and I can get it shown
Before
to you.
you leave, is there anything you want to say? Mr. Simon, this is your time, your life.
I just want to say that these 11 months I've been having time to think about it. I just been running through my mind every day. What bad decision I made.
What was your bad choices?
First being there, and then second is striking. Just involving myself in the situation.
Or were you not carrying a firearm?
No, sir.
We'll see what the video shows. But this states that you pleaded guilty to striking the victim about the head and the body with your hands and feet. And this states you used or exhibited a deadly weapon, namely a firearm, during the commission of the assault. I'm going to remind you, you pleaded guilty to that under oath. Did you lie
No, sir.
to me? You must, because these are the elements of the crime. That's what you pleaded guilty to. And here this states, we went over this. There's your signature right there. This states, I am mentally competent to enter my guilty plea. It's freely and voluntarily made. I have read the charging instrument, the indictment. My attorney has explained it to me. I committed each and every element alleged. I give up my rights to pre-sentence report. I am guilty of the offense and any lesser included offenses. I swear all of this is true, so help me God. Let me repeat once again. You swear all of this is true, so help me God. I've read the indictment. My attorney has explained it to me. I committed each and every element alleged. One of these elements that you admitted is you did then and there use or exhibit a deadly weapon, namely a firearm, during the commission of the offense. Did you just lie to me? That's what you're doing. You said you committed every element. She went over, she's a good lawyer. She goes over these things with you. One of the elements is you used a firearm during the commission of the offense. Not saying that you even struck or stuck it in the face of somebody or shot it. But when you're brandishing a gun and somebody sees it, it defends it. They're helpless. But this is what it said you did. You used or exhibited a deadly weapon. But you're saying I didn't even have one. Now, to me, which meant you must have lied when you signed this oath, which is perjurious. You commit perjury if you swear to something that's not true. we went over and we go over this real simple. I go over it with you and you sign everything and we do it as a great precaution so that people don't plead guilty to things that they're confused about or that are untrue. But we rely on this, the truth, and you swore to it. But now you're saying you didn't have a firearm. Shame on you one way or the other. Shame on you. You're caught in a box now, buddy. I don't like what has just happened. When you plead guilty and you're throwing yourself to the mercy of the court, you fess up to everything that's true. But you don't lie about it in an oath, which you may have done. This now you're saying, I didn't have a gun. But that's what this sworn, I'm showing what you signed. There it is. That's your signature under oath, buddy. I committed each and every element, and that's one of the elements. You either used or exhibited, showed a firearm, which causes people to be in fear, and then they're submissive. That's what happened. Apparently, in this case, looks like you were part of the beating, and people were beating the poor guy to almost to death. But using firearms, people are submissive, and they can't compete with a firearm. But you're saying you didn't have it, but you admitted it back on the date you signed this, and we went over it. I swear all of this is true, so help me God. What's your final answer? Or do I need to see the video? Did you have a gun with you or not? Let me see the video.
Okay,
And
Judge.
then we're going to have to, he's admitting he doesn't have a gun or exhibited it, which means we're not taking the deal. He'll go in front of a jury. And let me see that video.
Give me 5 minutes. I'm gonna get a copy upstairs.
You don't have a deal with me, buddy. And juries can't give probation they can give probation for deadly weapon, but they don't. But I'm not taking a deal when the truth is what's important. You can't play games, but I will ask the district attorney to look into a perjury charge for this, because you're not going to mislead me by swearing under oath that you committed all the elements of the crime when you didn't. And it's a felony offense to commit perjury. You don't want to carry that around the rest of your life. You're tabbed as a professional liar. But these are all choices that everybody gets to make. And you either make the right choice or the wrong choice. And you live by it, the right choice or the wrong choice.
Judge, if I may, I do believe we're dealing with a law of parties issue here, where all of the defendants were charged with an aggravated assault with a deadly weapon. And if another party had exhibited a deadly weapon, which is my understanding that one of them did, he would also be responsible.
A party too.
Yes. So while he may not have had a weapon on himself, he is still able to plead guilty and be guilty of that offense because of the elements of the law.
He would have to have known other people had the weapon and used it and took part in the assault.
Yes, Judge, and I believe that will be exhibited in videos.
Somehow assisted them in the commission of the offense. That right? Should have run like the wind away from that. You should have never been a part of this. You should have gotten away from it as fast as possible. What is looking for the extent of the injuries of the victim? Does anybody know?
I do not, Judge. This might be a better question for Mr. Mann.
He was listed in critical condition, according to the reports. Does anybody have a difference? It means he almost died. Really? There's 9 of you ganged up on it? 9? You see anything wrong with that?
A lot.
And this is all at 3:30 in the morning?
Yes, sir.
Is that right?
Yes, sir.
Nothing good happens at that time unless you're working. So you were 17 when this happened?
Yes, sir.
Is that right?
Yes, sir.
7 October, you turned 18 2 months later?
Yes, sir.
That's not evidence issue.
Let's take a look at the video on this in a minute.
Do you want to finish out the rest of the cases while we're waiting on that
What
video?
do we have? Just have a seat right over there, sir. And get that. Mitchell Sylvester, is that it?
Yes, that would be it.
Mitchell Sylvester. Thank you.
If you couldn't find it, I still.
You have everything to lose by misstating the facts. everything to lose when we find, especially when we learn from the video here, that was wrong, flat wrong. So when it states your version, I did not have a weapon, but other people did have guns, that was wrong. You looked me right in the eye and lied to me. And that's not the way to handle it. And we don't have to be up here showing you that you're not telling the truth for you to tell me the truth. You need to be honest from the beginning of this. What this is multi-level state of problems in this town, in this county, that is struggling with misbehavior, with the 16th highest crime rate in the state. There's nothing that we're proud about, and the people who are trying to be proud in the city and do the right things are having to deal with irresponsible behavior. This is occurring at a public place, a grocery store, at 3:30 in the morning. Everybody needs to be in bed or working, not messing around in a congregation of folks and then assaulting. And there was y'all attacked the guy like a pack of wolves. It's like a pack of wolves. And then anyone who has a firearm, anyone who is displaying or exhibiting a firearm is only going to throw gas on the fire because somebody sees this. When you pull it out, you're using it. And you're either going to use it for the wrong reason or someone's going to shoot you. But when you pull out a weapon, the people are submissive and you have the power over them, which you're not supposed to have. That's not the right thing. And then y'all all pounced on the victim, and there's no way he can defend himself. It's just not fair. It's just not fair. It's like playing on a basketball court and the other team shows up with 20 players and you're stuck with 5. It's not right. It's not fair. That's why sports, which emulates real life, good lessons with rules of behavior, are followed. And when you don't follow the rules, then it's a foul and you get punished. And same is in real life here. There are too many aggravating factors here that all add up to problems. But when you are rightfully accused, you don't lie like you did. Others have been forthcoming. And it's not as though you haven't had problems in the past. I'm looking at putting the city ordinance in the runaway. We've got evading arrest out of Harris County that was dealt with through the court. Unauthorized use of a motor vehicle that was, I think, dealt with in this county under juvenile matters, and then evading arrest with a motor vehicle. The point is, juveniles, people make mistakes. When you're young, you're supposed to learn from these mistakes and do better. And then after all of those situations that you had with court authorities, then on October 1st of 2023, after all of that, mistakes have consequences and you were dealt with them. And the right thing would, of course, learn from those mistakes. But here we are at 3:30 in the morning and you're displaying a gun. And whether you fire the gun or not, emboldens the person carrying the weapon, and it is not fair to others or being subject to the misuse of the weapon, like the victim in this case. They do not have their rights anymore because they are submissive, thinking they're about to lose their life, which is what happens when you brandish a gun. People are going to assume that death is a clock's tick away, and you're not supposed to have that power over other people. But all that being said, with all of those priors, then you get here and you lie, and we have to see the video. I wish you would have handled this a lot better and more honestly. Anything else to add? If If not, I'm going to find you have pleaded guilty in this case, Mr. Simon, voluntarily, knowingly, intelligently. There was sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here in this earlier plea hearing to find you guilty beyond a reasonable doubt. Before I move forward here, is there anything else you would like to add? Yes, sir. Go ahead.
John, lying, possibly saying that I didn't have a weapon. Just, I was misunderstood it. What, did I use it? I have it.
You told the probation officer, I did not have a weapon, but other people had guns. They don't lie. That's wrote down exactly what you told me. And that's what you told me. We had to prove otherwise. Anything else? I hereby find you guilty beyond a reasonable doubt of this second-degree felony of aggravated assault with a deadly weapon. I'm following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 10 years. The judgment shall reflect an affirmative finding that a deadly weapon, namely a firearm, was used or exhibited in the commission of this offense. Do you understand what has happened today, sir? You will be given credit for all time you have served. Anything else?
No, sir.
That is all. I am really disappointed that this one worked out this way. I thought that you were going to handle this a lot better. That is all.